Hello everyone, this is your host Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with the latest development in the Krishna Janmabhoomi Shahi Idgah Mosque dispute. The Supreme Court has disposed of an appeal filed by the Mosque Committee challenging a High Court direction to consolidate 15 suits in the case. The bench of Justices Sanjeev Khanna and Dipankar Datta was informed that the Mosque Committee has already filed an application in the Allahabad High Court for recalling the order under challenge. Therefore, the court suggested that the application be heard first before the special leave petition is considered. Accordingly, the Mosque Committee's SLP was disposed of. The Supreme Court bench led by CJI Chandrachud today agreed to hear the plea on election freebies. Election freebies are the incentives, gifts or promises that political candidates offer to voters during an election campaign. These freebies are often designed to sway voters and gain their support. These might be promises of financial benefits, subsidized goods and services or cash handouts. Today, senior advocate Vijay Hansaria, appearing for petitioner, requested an earlier listing of the pending matter of the distribution of freebies from public funds by political parties. He also highlighted the issue of absence of any provision in the Representation of People's Act of 1951 giving powers to the Election Commission to deregister a political party. Agreeing to the urgency of the matter, the CJI agreed to retain the case on the board. You are aware that various pleas have been filed in the Supreme Court challenging Chief Election Commissioner and other Election Commissioners Act of 2023. The petitions question constitutionality of the act signed into law by the President following the Parliament's winter session. The crux of the batch of petitions revolves around the contention that the Election Commissioners Act overturns the Constitution Bench decision in Anup Baranwal case. The legislative change removed the Chief Justice of India from the committee responsible for appointing the Chief Election Commissioner and other election commissioners, leading to this constitutional challenge. The centre has now opposed the batch of pleas seeking a stay on the act. In a sworn affidavit by an additional secretary in the Law Ministry, the Union government refuted the petitioner's claim that the two election commissioners were hurriedly appointed on 14th March to prevent any court orders the following day when the matters were scheduled for interim relief hearings. Among other things, the centre has argued that the 2023 Act is a significant improvement in the appointment process of election commissioners, asserting that it provides for a more democratic, collaborative and inclusive exercise. It has also underscored the Act's purported alignment with the principles laid down in the Anup Baranwal case, stressing that the legislation is in harmony with the constitutional framework. The affidavit also mentions that the independence of Election Commission as well as any other organization or authority is not dependent on or affected by the inclusion of a judicial member in the selection committee. The Supreme Court is set to hear the matter tomorrow. Stay tuned. A bench comprising Justices Sanjeev Khanna and Dipankar Datta today heard the bail application of Prem Prakash, who is alleged to be the aide of former Jharkhand Chief Minister Hemant Soren in a money laundering case. Justice Khanna, in an important observation today, said that Section 45 of Prevention of Money Laundering Act does not bar a court from granting bail to an accused if there is prolonged incarceration and delay in trial. For your information, according to Section 45, bail can be granted to an accused in a money laundering case only if twin conditions are satisfied. There should be a prima facie satisfaction that the accused has not committed the offence and that he is not likely to commit any offence while on bail. Noting that in the present case, the accused had spent 18 months in jail, Justice Khanna said that the right to bail on the ground of prolonged incarceration is something which flows from Article 21 of the Constitution, which is not taken away by PMLA. Although the bench was initially inclined to grant interim bail to the accused, but at the request of Additional Solicitor General, it adjourned the hearing by a month to ascertain the progress of the trial. Also, the trial court was directed to expedite the trial and conduct it preferably on a day-to-day basis. The Delhi government today sought an urgent hearing of its petition which seeks the release of Delhi Jal Board funds worth Rs 3,000 crores. In November last year, Delhi Minister Atishi had alleged that the Finance Department had withheld the funds for the Delhi Jal Board on the instructions of the Chief Secretary Naresh Kumar. She said that Delhi will witness a severe water crisis if the funds were not released. Today, senior advocate Abhishek Manu Singhvi, appearing for the Delhi government, stressing the urgency of the matter, informed the bench led by Chief Justice of India Chandrachud that the funds will lapse by 31st March. It was emphasized that the centre has not released the funds despite the passage of the budget in the Assembly. The CJI, however, said that the matter will be heard on 1st April. The court reassured that in case the bench rules in their favour, the lapsed fund would be reversed and any developments that take place between today and the day the hearing would be taken into consideration by the court. The Supreme Court has today granted interim bail to arrested Enforcement Directorate Officer Ankit Tiwari. Tiwari, who was arrested by the Tamil Nadu Directorate of Vigilance and Anti-Corruption in December, approached the Apex Court after his second bail plea was dismissed by the Madras High Court last week. A bench of Justices Suryakant and K.V. Vishwanathan has been hearing his special leave petition against an earlier order of the Madras High Court denying him regular bail. After his second bail application was also dismissed by the High Court, he filed an application in the pending case as well as a separate SLP. In response to his latest pleas, the Supreme Court today directed his release on interim bail. However, this interim relief comes with several stringent conditions. In another notable development, the bench adjourned until 18th April the hearing of the separate plea filed by Enforcement Directorate seeking the transfer of probe into bribery allegations against Tiwari from the Tamil Nadu DVAC to the CBI. Do visit livelaw.in to read about this in detail. Coming to an update from the Delhi High Court, which today rejected a PIL seeking direction on the Union Government and Election Commission of India to register a complaint and prosecute politicians, namely Rahul Gandhi, Arvind Kejriwal and Akhilesh Yadav, for making allegedly misleading and false statements with an intent to damage India's image and credibility. The PIL was moved by Surjit Singh Yadav, who claims to be a social worker. He was aggrieved by allegedly false statements made by the three politicians regarding alleged waiving of loan by the central government of rupees 15 or 16 lakh crores of few industrialists. It was argued that the statements were published to create confusion in the minds of public so that the image of the central government could be downgraded. A division bench of Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora closed the PIL and observed that the industrialists and individuals who are alleged to have been defamed have the means to approach the court themselves. The court was also of the view that the petitioner underestimates the wisdom of Indian voter. Next, coming to a short update on the Cauvery river water dispute. This ongoing conflict involves the states of Karnataka and Tamil Nadu. The dispute started in 1974 when Karnataka began diverting water without Tamil Nadu's approval. After the Cauvery Water Dispute Tribunal finalized a water sharing formula in 2007, the matter escalated to the Supreme Court. Alongside water allocation, the tribunal suggested establishing a Cauvery Water Management Board and a Cauvery Water Regulation Committee. In 2018, the Supreme Court made some adjustments to the tribunal's decision. In an original suit filed by the state of Karnataka against Tamil Nadu, Kerala and Pondicherry over use of Cauvery river water, the Supreme Court has now framed issues and has directed parties to file documents within 6 weeks. The matter is next listed for directions on 7th May. Stay tuned. Certain dog breeds have been under government scrutiny for their aggressive behavior. Due to increasing cases of dog attacks, the Union Ministry of Fisheries, Animal Husbandry and Dairying Department issued a circular last week urging state governments to ban the import, sale and breeding of 25 aggressive dog breeds, citing them as a threat to human safety. The circular also requires those who have reared the aforesaid breed of dogs as pets with them to sterilize their pets and stop further breeding. In this regard, an update has come from the Karnataka High Court, which today heard a petition filed by dog breeder against the ban. A single judge bench of Justice M. Nagprasanna has stayed the operation of the circular in the state of Karnataka. This was because during the hearing, the Deputy Solicitor General of India informed the court that the impugned circular was issued after Delhi High Court passed an order in a PIL asking the government to decide on banning the license for keeping dangerous dogs. However, Justice Nagprasanna pointed that the Delhi High Court was unequivocal in directing that all stakeholders, not a few or various, but all must be consulted before consideration of the representation. The court noted that the Kennel Club of India, which has various chapters all over the nation, has not been heard. After this, the court stayed the circular and directed the Deputy Solicitor General to produce those documents that went into decision of making of the impugned circular. The matter will now be heard on 5th April. Stay tuned. And lastly, the Supreme Court today granted bail to Hyderabad-based businessman Abhishek Boinpalli, accused in a money laundering case related to Delhi liquor policy, for 4 weeks. Boinpalli, a former director of Robin Distilleries LLP and an alleged middleman, is under investigation in this case. He was arrested by the CBI in October 2022 but obtained bail in the CBI case a month later. However, his relief was brief, as at the same time, Special Judge M.K. Nagpal granted the Enforcement Directorate's request to detain him for 5 days. Since October 2022, he has been in custody as per the trial court's order. Today, a bench comprising Justices Sanjeev Khanna and Dipankar Datta was hearing his SLP filed against the Delhi High Court's judgment of July 2023 denying him bail. The bench today ordered the petitioner's release on interim bail for 4 weeks from the date he is released, on the terms and conditions to be fixed by the trial court. The matter will now be heard on 29th April. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.